Everybody, Mark Stiles down here at Studio B at 892 once again with one of our lead real estate attorneys from Stiles Law. You've probably seen our video about condominium conversions and tenancies. If you haven't, you can see those on our YouTube channel. But welcome back, Emmanuel Ebot. How are you, buddy?
Thank you. I'm doing well.
Hey, so a lot of questions we've been getting lately about investment properties and landlord-tenant. And a lot of the clients that are coming in have said, hey, I would love to buy investment property, but I hear that Massachusetts is really tenant friendly, more so than tenant friendly, but there's an imbalance in the court system between landlords and tenants. Is that true?
Well, I'm going to start off by giving you a lawyer answer in that it really depends. So the landlord-tenant laws are actually relatively similar to other states. The difference that we have here in Massachusetts is that there's just a litany of rules that you have to follow as a landlord. So if you were to not follow all the rules the way in the sequential order that they're required to, that's when it becomes difficult as a landlord.
So I understand. So a do-it-yourselfer might get into more trouble than someone who's represented by an attorney.
Yes, and again, I've been doing this for 12 years. There are a lot of rules, so it's very important to read the statute and follow them precisely to the letter. Because if you start down the path and you've missed something that you should have done, that's when you really find yourself in a lot of trouble.
And then the time and the money and the expense really adds up and makes people think that it's unfair, right?
Exactly. So usually, again, if you're ever in a housing court scenario and a judge determines that you did not follow the rules, the remedy is that you have to start all over again. So just think about it. So this is a rental that you're relying on funds coming in, that's just another 3-4 months that you're going to have to go without that rent coming in because you didn't do the steps from the beginning.
Okay, so if somebody were to purchase an investment property and they wanted to be really proactive and do all of those steps, what can they do to help protect themselves in the case of having to go to court?
That's a good question, and I think that's what I advise my clients all the time when they call me. So the first thing is you have to do your due diligence with your tenants. You're never going to go wrong by making sure that the people that you're putting into your rental property are trustworthy and that they're going to abide by the terms of the lease that you have in front of them. Second thing is, again, you really do have to comply with the terms of the statute. So conduct the walkthrough with the tenants, with them, making sure that you're making note of the condition of the property when it's turned over to the tenants.
I have a client, Emmanuel, sorry to interrupt you, but they take it the step further and take a picture in each room of the unit with the current day newspaper so that there's no question that these were the conditions of the property at the time.
I've not heard of that, but that's a good idea.
Yeah.
So anything that can help you document the current condition of the property when the tenant moves in is only going to help you down the road.
What about escrow? So people hear about escrow, there's security deposits, there's triple damages, attorney's fees. That's one of the things that scares most of the people when they're sitting in talking about getting an investment property.
And believe it or not, that is really the area of the landlord-tenant disputes that most landlords trip up. Because again, there are rules in place and they require you to, if you're going to take a security deposit, you have to put it into a separate account that does not commingle with your funds. You're going to have to notify the tenants in a timely fashion where this money is, and if there's any interest that accrues, that has to go back to the tenant. So there are these types of rules that are part of the security deposit law here in Massachusetts that if you don't follow them to the T, you wind up in a world of trouble.
And the idea is to protect the consumer, which is the tenant. But yet, to follow the rules, it's not that hard if you do it correctly.
That is correct, because let's keep in mind the security deposit is the tenant's funds. So it's important that that's kept in a secure account. So when the tenant has lived there for the period of their tenancy and has delivered the property back to you as a landlord, they get a return of deposit and they are comfortable that they are going to get that money back.
And that money needs to be outside of the landlord's personal banking account.
That's right. It can't be in your bank account. It can't be commingled with other bank accounts that you may manage. So make sure that it's separate and that you let your tenant know exactly where that money is and with the account information etc.
And what about leases? Do we recommend handshake? Do we recommend at will? What are we doing about leases?
Definitely recommend leases. It's important that the terms of the agreement between yourself and your tenant is documented in writing. So if you don't want pets in there, you want to make sure that that's in your lease. If you want quiet hours between 10 and 8 a.m., you got to make sure that's in your lease. And it's important because when there is, if there's ever a dispute between your tenants, you really rely back on the lease to see what was agreed upon at the beginning of the tenancy.
Got it. All right, so let's say that the investor made a purchase of property, has been very proactive with their documentation and following the statute as closely as possible, but something still goes badly with the tenant. What happens next?
Well, there's two ways to terminate a tenancy here in Massachusetts. The first way usually is when the tenant doesn't pay the rent. That's usually the big area where landlords are looking to replace a tenant. You would start that process with giving what we call a 14-day notice to quit.
Okay.
And that's simply a notice to the tenant, letting them know that they have not paid the rent, which was required, and giving them 14 days to vacate the property.
And if they don't vacate in those 14 days, change the locks, put their stuff on the sidewalk?
we wish, right? Though in some states, as I've heard, that's the case, but in Massachusetts, it's not. So you are required to give that 14-day statutory notice, and if they're not out, you then have to take your case to a court of law and have that adjudicated there before you have the right to have them.
And that's where not being proactive would probably be exposed to the judges and mediators at those housing courts.
That is correct, because when your case is in front of a judge, whether in a housing court or a district court, they look at the full tenancy. They make sure that you as a landlord followed all the rules, and if you haven't, they usually require you to start over, which, again, like I mentioned before, is time and money and effort that with most people, they just can't afford at that time.
And it can be avoided if they're proactive.
That is correct.
Okay. So, Emmanuel, if someone were to want to purchase an investment property, if they were looking to be proactive with their tenants and make their tenant experience the way it should be following the statute, or they got themselves into a situation where they need to remove a tenant, how would they get in touch with you?
Well, it's easy. You can see on the screen right now, you can call me at 781-319-1900, or you can go to our website, styles-law.com, and give us a call, and we'd be happy to help.
Thank you all for watching. I hope this content was helpful and informative. If it was, please subscribe to our YouTube channel so you can get all of our videos, and comment, and if you like, please share. Thank you very much for watching.